Good afternoon. Thank you for joining us for Keeping It Legal for Nonprofits. My name is Susan Jacobs, and I'm with South Florida Community Development Coalition. We're a nonprofit membership organization primarily focused on affordable housing and economic development as pertaining to individuals and communities with low incomes. Primarily, we work on building partnerships, policy research and education, and capacity building, which the last one is why we are hosting this webinar today, because legal issues can affect the foundation of an organization and its capacity to serve. Just so we learn a little bit more about you, let's go ahead and take a quick poll. Okay, we'll leave that up for a couple of seconds. Okay, let's see. Okay, it looks like we have quite a few folks in the middle range there, and a few people who are thinking of starting a nonprofit or joining a nonprofit board. All right, great, thank you. As far as a little housekeeping, if you have a question that you think of during the webinar, feel free to go ahead and put it in the chat box, and you can send it to us. We'll be collecting those throughout, and then at the end, we'll reserve about 15 minutes to go through those questions. Today, we are fortunate to have a presenter, Shahrzad Emami. She is currently the Director of the Community Development Division at Legal Services of Greater Miami. She also teaches at University of Miami Law School, and she recently started or became the director of a new regional collaborative on community development attorneys called Florida Community Development Legal. It's a partnership between 3 legal service agencies in Florida, and it's going to be starting up this February, and it'll be staffed with 7 attorneys, all specializing in affordable housing and community development. Their service area will be from Orlando and Tampa down through Key West. And so without further ado, I'm going to go ahead and pass it off to Shar.
Thank you so much, Susan. Welcome everyone on the line. Thanks for joining the webinar today. Susan, I can't see the introductory screen. I still have the poll screen up.
Okay, there we go.
There we go. Okay. So just to get this out of the way, I have to do this brief disclaimer. I work for Legal Services of Greater Miami. We are a nonprofit law firm providing free legal assistance to low-income individuals and also to nonprofit organizations, and most recently to small businesses that are eligible for our services. However, today, during this webinar, we are not providing legal services or legal advice. This is a training for informational and educational purposes only. You should seek legal counsel and independent tax advice regarding any topics that we cover in today's discussion. And this training finally does not create an attorney-client relationship between Legal Services of Greater Miami and the participants. So now that we've gotten that out of the way, we can go to the next slide. So just for a brief introduction to those of you who have not started a nonprofit corporation but are thinking of doing so, there are several steps that you must follow in order to form a nonprofit organization, and we suggest that you retain legal counsel in order to do so that it's done properly, especially if you want tax-exempt status, which is a tax status that is given to nonprofit organizations that qualify from the IRS. So first you would form your nonprofit corporation if it was here in Florida with the state of Florida. And then after you formed your nonprofit organization, you would then apply for what we call 501c3 tax-exempt status. And some of the things that you have to include in your articles of incorporation in order to get that tax-exempt status is your corporate purpose, being exclusively for charitable or educational purposes. And so there are several limitations as well. No private benefit, there are limits on lobbying, you must dedicate your assets to a charitable purpose, and upon dissolution, the distribution of assets must go to another exempt organization. So we're going to focus on some of these limitations right now. For the existing nonprofit organizations that are on the call, you have to abide by these limitations throughout the life of your nonprofit corporation's existence. So let's go through specifically these three. First, no private benefit. What does that mean? This also is referred to as private inurement, and this means that when someone or an entity receives a benefit from a nonprofit organization, NPO is the abbreviation we'll use throughout the webinar, if that benefit is greater in value than what the nonprofit organization received in return. That's the basic definition. So how do we guard against a possible claim of private benefit or private inurement? Every nonprofit organization must adopt a conflict of interest policy. You are required by the IRS when you file your Form 1023 to get your tax-exempt status to attach a copy of your conflict of interest policy. So you should have this conflict of interest policy on hand. It should be updated regularly, and you must follow the policy. You should include indemnification language in your bylaws additionally. And third, you should probably also always purchase director and officer liability insurance. There are protections for directors and officers that serve on a nonprofit board of directors, but those protections are not absolute. Those protections are afforded via Florida statute, but as we all know, there is no prohibition on somebody suing someone else. So even if a nonprofit organization does everything right and their directors and officers act in accordance with legal standards and in accordance with their fiduciary duties, someone can still sue you or the organization. And that's where your director and officer liability insurance would kick in. There are some examples of problems that we commonly see in this area. For example, paying a board member a bonus simply for a job well done without any justification or reasoning, paying a staff member or an employee unreasonable compensation or bonuses, spending an unreasonable amount of money on a board retreat, or an individual staff member or board member individually profiting from the nonprofit organization. You have to remember that every decision of a board member must be to advance the nonprofit's purpose. Susan, can you switch to the next screen? I'm having difficulty going to the next screen. If you want more information about bonuses in particular, this is a common question that we often get here at Legal Services. There's actually an IRS general information letter on the topic. You can go to that letter and read it and refer to it on when and how you can give bonuses to employees of your organization. And it also talks briefly about bonuses to board members and whether or not that is viewed favorably or unfavorably by the IRS, depending on the situation. So if you are accused of receiving an improper benefit from a nonprofit organization, what happens? Well, the IRS can impose financial sanctions on board members, officers, and related persons for what they call an excess benefit transaction. So what is an excess benefit transaction? We just really talked about it, but it's payment of compensation or the transfer of property where that individual or organization receives more than the fair market value from the organization, or pays the organization less than fair market value for property or services received. The tax that's imposed is 25% of the excess benefit amount, And then if you don't correct it, it can go up to 200% of the excess benefit amount. The tax can also be levied on anyone that approved the excess benefit transaction, like a director, officer, or manager, and that tax is 10% of the excess benefit amount and a maximum of $10,000 per transaction. So this would be a situation where either the board or an individual of the organization approves that somebody receives something from the organization that is more than fair market value for the services that are rendered, or conversely, pays the organization. For example, let's say the organization is selling a piece of property and the organization sells that piece of property at less than fair market value to an individual or another organization, and does so at the detriment of the organization. That would be considered an excess benefit transaction because somebody is receiving a benefit from the nonprofit organization that otherwise they would not receive. Let's talk about lobbying. I often get questions about lobbying for nonprofit organizations. The general answer is that a 501c3 organization can engage in lobbying activities, but it's substantially limited. And the IRS has a sort of it's not a hard line rule, but it's an average from reading through all of the IRS letter rulings. You sort of get the idea that the IRS does not want a nonprofit organization doing more than 5% of their overall expenditures and activities going towards lobbying activities. If you think that you're going to be doing more than 5% of your activities on lobbying, you can file a form with the IRS and make the 501H election, which essentially outlines how much lobbying you think you're going to do, how much time you're going to spend on it, and how much money. You tell the IRS this in advance, and then they approve you for up to that amount. Usually, if you want to do 10% of lobbying activities for your organization, it's often beneficial to make this 501H election. One thing that's absolute is that nonprofit organizations cannot do anything that would support or oppose anyone running for office. That's a no. If you think that this is what your organization wants to do, there are other options for you. You could form a 501c4 social welfare organization. You could form a political action committee. Some chambers of commerce and business leagues do these. The 501c6 is what they are called. So there are other options if you think that one of the primary activities of your nonprofit organization is going to be lobbying. But if you're a 501c3, the limits are pretty absolute. You can often engage in some activities which may or may not be considered lobbying. Education in general, if you're providing education on a topic and it is nonpartisan, that's usually not considered lobbying. You can engage in public forums if it is nonpartisan in nature. You can engage in voter registration without bias, but you have to remember that your lobbying time and money still must be limited to that less than 5% amount. The second major purpose of a nonprofit organization, and one of the things you have to include in your articles of incorporation, is that you must dedicate your assets to a charitable purpose. So if you are an officer or a director of a nonprofit, you need to remember that everything must be done to benefit the purpose of the nonprofit exempt organization. And for those of you that are thinking about forming a nonprofit organization, you should probably ask yourself the following questions. Does your organization need grants and tax-deductible contributions to operate? If the answer to that is yes, then you might want to consider becoming a nonprofit organization. Do you want to have complete control over the organization and retain most, if not all, of the profits? If the answer to this question is yes, then you should probably not be a nonprofit organization. A nonprofit organization is controlled by its board of directors, not an individual. And even though a nonprofit organization can make profits and generate profits, and to be successful, the nonprofit organization most certainly should, those profits have to be reinvested back into the operations of the nonprofit organization or paid out to its employees as reasonable compensation for services rendered. And the third question revolves around designated gifts. Designated gifts to a particular purpose or person. Donors can request this, but they cannot require the funds go to a specific individual. They can require that the donation be used for a specific purpose, however. So if you're thinking about forming the nonprofit organization only so that you can accept a gift so that that individual can get a tax deduction and then you can turn around and give that gift to a specific individual, that would not be an authorized use for a nonprofit organization. So what exactly does the 501c3 status mean? The 501c3 status is a tax-exempt status that you get from the IRS. This is very important if you wish deductibility of gifts to your organization as a charitable contribution. That's one of the major benefits of 501c3 status. There's also a benefit in receiving grants. If you're a 501c3, sometimes you can apply for various types of grant funding that require 501c3s to be the applicants. You can use tax-exempt bonds to fund activities. And as a 501c3, depending on the circumstances, you can also be exempt from state real property taxation and sales and use tax, which is governed by the Florida Department of Revenue. You have to be operated exclusively for charitable, religious, educational, literary, or scientific purposes. No part of your earnings can inure to private individuals. That was the private inurement that we just talked about. You cannot carry on substantial activities, any more than 5%, to influence legislation. Cannot participate in any way in any political campaign. So there are various Florida regulations over nonprofit organizations, and these are enforced in our state by the Attorney General. You have to be certain that once you form your nonprofit organization, that you are actually abiding by your articles of incorporation and your bylaws. So once you adopt your bylaws and appoint your initial board of directors, you should have common practice having a minute book. And the minute book should have accurate and up-to-date information from your meetings. The minute book will also serve as a protection from personal liability for individual board members when they are voting on a matter. And you should include the minutes for every board meeting in that minute book. We recommend that the minute book and the meeting minutes be short and to the point. Your corporation is going to be governed by your bylaws. These are the internal rules of a nonprofit organization. These should be constantly reviewed and updated in accordance with how your organization is actually operating. This is the force of law within your organization. You must follow the formalities of your bylaws in order to receive the coveted corporate liability protection that you have in forming the corporation. Your bylaws are not filed with the Secretary of State. These are internal to your organization, and in general, it sets out the structure of your organization. Whether or not your organization is a membership organization or not, how many directors you have. If you wish to apply for tax-exempt status, you have to have at least 3 directors. Remember that directors are the ones that make policy decisions, and they act in accord with one another. So directors are always going to act as a group. And they also delegate the actual operation of the nonprofit business to the officers. Your officers are also going to be laid out in your bylaws, how many you have and what their roles and responsibilities are, and whether or not you have any committees. Some examples of committees that nonprofit organizations can have are executive committees, governance committees, finance, audit, and personnel committees. This next slide simply lays out what you want to do at your first board meeting, your initial board meeting, and then what you want to do at every subsequent board meeting. You need to make sure that at every subsequent board meeting that you do have a quorum of directors present and they must be able to simultaneously hear each other. If your bylaws authorize it, you may do business via the phone or web conferencing, but everyone must be able to simultaneously hear each other speak. If all of your board of directors are not present for a meeting, you can pass resolutions by unanimous written consent. And any time an item is discussed and a major decision is made, that in which your bylaws requires a board vote, you should pass a resolution and then document that resolution in writing. The next slide is a section from the Florida statutes on directors and officers liability. I'm not going to read through the entire slide. You'll have this slideshow after the webinar, so you can go back and take a look at this. But in general, directors and officers are shielded from liability. They are not personally liable for monetary damages to any person for a statement, vote, decision, or failure to take an action regarding the organizational management or policy by an officer or director, unless, and this is the big unless, any of the following apply. The officer or director breached or failed to perform his or her duties as an officer or director, and one of the following, which is that the breach or failure to perform constituted either a violation of criminal law, a transaction in which the officer or director derived an improper personal benefit, either directly or indirectly, or recklessness or an act or omission that was committed in bad faith or with malicious purpose, in a manner exhibiting wanton and willful disregard of human rights, safety, or property. So in general, directors and officers, if they're doing what they are supposed to do, and they are, attending meetings and listening to the matters that are brought before them and following their fiduciary responsibilities and making informed decisions, in general, this statute serves as a protection for them. Like I said before, however, that doesn't mean that anyone is immune to a lawsuit. And in the event that a lawsuit would be filed, even if the director or the officer did follow all of the proper procedures and did everything in accordance with law, someone still could file a lawsuit. And in that case, that's why we recommend that all nonprofit organizations purchase directors and officers liability insurance. Record keeping. Record keeping is extremely important for a nonprofit organization. By statute, you have to keep a copy of the following on file at your main office at all times: articles of incorporation, any amendments, the bylaws, and any amendments thereto, and minutes of all member meetings for the past 3 years, in addition to written communication to all members generally, or all members of a class within the past 3 years, including financial statements furnished for the past 3 years. A list of names and businesses, street or home address of current directors and officers, and your most recent annual report delivered to the Department of State. Taxes. Nonprofit organizations can be exempt from sales and use tax. In order to be exempt from sales and use tax in the state of Florida, you have to file what's called a DR-5 form. This is an application for Consumer Certificate of Exemption, and that's filed with the Department of Revenue. If you are a 501c3 nonprofit organization, then you are exempt from state corporate tax unless your nonprofit is generating what we call unrelated business income, and we'll talk a little bit about that in a later slide. For property taxation, if you own property and if you're a nonprofit organization that uses that property for your exempt purpose or for another exempt purpose, such as affordable housing, you can apply for property tax exemption in the county where the property is located. If you're a nonprofit organization, you are not exempt from municipal taxes. There are state reporting requirements if you're a nonprofit that's governed under Florida Statute, Chapter 617. You have to file an annual report with the Department of State by May 1st, and you have to do this annually. There's also what's called a solicitation and contributions form. Oddly enough, this is filed with the Department of Agriculture and Consumer Services. And if you're going to engage in any solicitations or receive any contributions, you must file this form. And this is also renewed annually. Now on to the federal regulations for 501c3 nonprofit organizations. Most nonprofit organizations want to be a public charity. This is because if you're a public charity, you do not have to pay any tax whatsoever, any income tax. However, to be a public charity, you have to be publicly supported, and we call this the 1/3 test. At least 1/3 of your support has to come from the government and the public. You are considered a private foundation if you are controlled by a donor. Private foundations are subject to taxation. They are subject to a 2% excise tax on net investment income, and they also have minimum requirements for distribution of income and principal for charitable purposes. As a 501c3 nonprofit organization, you do have a filing with the IRS every year. You have to file a Form 990. If your gross receipts are less than or equal to $50,000 a year, you can file what's called a Form 990N. This is also known as the e-filing postcard. If your gross receipts are less than $200,000 a year and you have assets less than $500,000 a year, you're allowed to file what they call the 990EZ form. If, however, you have total assets greater than or equal to $500,000 and receipts greater than or equal to $200,000, you have to file the full Form 990. This is due the 15th day of the 5th month after the tax year ends. So, for example, to file the Form 990 for fiscal year 2017, you would have to file it by May 15th of 2018. And the Form 990 is a public document. The Form 990 discloses financial information of the organization, such as gross income, compensation paid to officers, directors, and trustees, payments to the 5 highest paid employees, disclosure of major donors, and it's basically a public relations document. It tells the story of the organization. And these forms I just discussed. This 990EZ. If you do have unrelated business income to your nonprofit organization, there's another form you have to file, which is the 990T. Some organizations are actually exempt from filing Form 990. Interestingly enough, churches, if you are a church, you actually don't even need to apply for 501c3 status. The IRS considers churches to automatically be tax-exempt entities. However, we recommend that churches still file for the tax-exempt status so that they have an actual letter from the IRS saying that they are, in fact, exempt. But as a church, you are exempt from filing the Form 990. There are severe IRS penalties for not filing your Form 990. They will take away your tax-exempt status. That's the most severe penalty for organizations that don't file for 3 consecutive years. So a lot of clients ask me, how do I avoid getting audited by the IRS? You know, what are some things that I really need to outright avoid and protect against? So these are what I consider red flags for the IRS. You want to carefully scrutinize any transactions that could be seen as self-dealing or private benefit, right? So these are transactions between the organization and outside third parties or its directors, affiliates, or major donors that could be seen as private enormous. Also, excessive executive compensation. This is often looked at by the IRS. You have to ensure that for your paid employees that the board has approved reasonable and not excessive compensation for your employees, such as your executive director. That's a fiduciary responsibility of every nonprofit board. So you need to make sure that that is done. You have to make sure that substantial business activities are related to the organization's exempt purpose. If a substantial business activity is unrelated to the organization's exempt purpose, this is a red flag for the IRS. If you engage in activities that are political in nature, also a red flag. Improper record keeping, not keeping an up-to-date minute book, for example, and also failings to file your taxes. That's a red flag as well. The IRS does have some safe harbor rules for transactions. Even if the transaction is scrutinized, the IRS, it may still pass muster with the IRS if there is an independent board approval of the transaction. There's reliance upon data or comparables, and there's adequate maintenance of records. Usually this is in the case of an improper benefit transaction. If a transaction is scrutinized as being considered private enormment and self-dealing, if these three bullet points are followed, and you can prove that it was not an improper or excess benefit transaction and that there was no private enormment, the IRS usually looks to these three items. Commingling funds. Nonprofit organizations are separate organizations, and as separate freestanding organizations, the nonprofit organization should not be passing funds back and forth to subsidiary companies or to personal accounts of employees, officers, or directors. Everything needs to be done what we call at an arm's length transaction, meaning that, let's say, a board member decides to loan money to the nonprofit organization for a particular purpose. As long as the loan transaction is documented properly and it's voted on by a disinterested group of the board of directors, not the one that's making the loan to the organization, then that is a way to document that transaction without commingling the funds. So there will be a paper trail, a loan document that evidences the loan from the board member to the nonprofit organization with repayment terms. The nonprofit organization should also keep separate accounts for its various activities, and also separate accounts for its various subsidiaries, and separate EIN numbers for its various subsidiaries. We're trying to guard against any potential claimants that might want to pierce the corporate veil. The third bullet point talks about unrelated business income. If a nonprofit organization engages in a non-exempt activity that is unrelated to the 501c3's corporate purpose, the revenue from that activity might be taxable. And if the revenue is considered taxable, the nonprofit has to report it on Form 990T. Always remember that unrelated business income cannot be a substantial part of the organization's overall activity, or the entire 501c3 status could be at risk. Donations, loans, and grants. 501c3s can support other 501c3s, and 501c3s can give funds to non-501c3s, but they have to make sure that in doing so, a charitable purpose of the 501c3 is served by giving the for-profit the funds, and that those funds are not used for a private benefit or for the for-profit organization private benefit or for an individual. The rule that I like to give my clients is that if you could not do the activity yourself as a nonprofit, then you shouldn't give funds to another entity to do that same activity. For example, a 501c3 cannot engage in political activity. So if the 501c3 gives funds to another organization to engage in that same political activity, then you are jeopardizing your tax-exempt status. Compensation issues often come up with 501c3 organizations. Excess compensation, but also classifying employees and classifying independent contractors. So the IRS will always review misclassification of employees when they come in to audit a 501c3. So you have to be very careful about the distinction. Remember that employees, you have to pay and withhold taxes. And if they are truly employees, then the IRS is going to look at the relationship of the business and the worker. So they're going to look at three types of evidence: behavioral control over the worker, financial control over the worker, and the type of relationship between the parties. If your organization controls how the individual is working, where they are working, how much time they are working, if you're providing equipment for that individual to work, then that individual is likely considered an employee and not an independent contractor. As a nonprofit organization, if you're going to have employees, you should do an annual review of your employees so that you have something documented. Make sure that you are also complying with any and all policies that are applicable. There are state and federal laws that apply to nonprofit organizations, just as in other organizations. Remember that nonprofits are subject to anti-discrimination laws, and if large enough, some other federal laws such as the Family and Medical Leave Act, or FMLA. I would consult with an employment attorney if you have a nonprofit organization that has employees to make sure that you are in compliance with all of these standards. It's also a good idea to hire or appoint an HR director if you have a staff, a large number of employees, so that you have someone on staff that's familiar with these laws and that can monitor their enforcement. Many nonprofit organizations like to have employee handbooks. Employee handbooks are a good way to write down the policies, including the anti-discrimination policies and federal laws that you have to comply with as an organization. However, you have to make sure that the employee handbook does not contain information about the tenure of the employment. Remember that Florida is an at-will employment state, and we generally do not recommend that nonprofit organizations or any organizations have employee contracts with individuals that they hire. And if you have an employee handbook that looks like an employment contract, it might be interpreted as such. Nonprofit organizations always like to have volunteers, right? This is one of the great benefits of being a nonprofit organization, is that individuals and other organizations love to volunteer. However, as a nonprofit, you do have to limit your liability if you have volunteers. Remember that volunteers performing services on behalf of the organization, if something happens, the organization can be held liable for any resulting harm. So there are ways to limit your liability. Obtain insurance to cover your volunteers, screen your volunteers, have the volunteer agree that they will abide by all the policies of your organization, provide sufficient supervision for the volunteer, consider having the volunteer sign a waiver and release of liability, remember that in order to function as a nonprofit organization, one of the most important things is accurate records management. Sometimes nonprofit organizations have their HR directors be their records managers as well. You should adopt a records management policy and always use an accountant and legal counsel when you have questions or when you don't know the answer to something.
Okay, thank you so much, Shar. We really appreciate it. And let's get on to a couple of questions. The first one here is, can you give examples of unrelated business incomes that a lot of nonprofits have?
So there's lots of examples of unrelated business income. It's really fact specific. The example that I use when I teach and when I are trying to explain this to my clients is, let's say you have a nonprofit organization whose substantial mission is the provision of affordable housing. And they own and operate affordable housing properties, and that's the mission of the nonprofit organization. And then let's say that that nonprofit decides that they want to open up a cupcake shop in a building down the street. And they lease the property and, they staff it and they sell cupcakes. Well, selling cupcakes and making money from the sale of cupcakes is not related to that nonprofit's mission. Selling cupcakes is not a charitable purpose. And so the money that that nonprofit organization makes from the sale of those cupcakes is going to be considered unrelated business income, and the nonprofit will have to pay tax on that unrelated business income.
Okay, it also looks like, could you explain a little bit more what you mean by piercing the corporate veil?
So organizations are formed normally for two purposes: liability protection and taxation. So if an individual is out there operating a business, there's nothing to say that the individual cannot operate the business as an individual. However, if something happens and that individual is sued, they are completely open up to liability. If the individual decides instead to form a business entity and to operate that business as a business entity, the individual that is responsible for that business would not be sued. The business entity would be sued. We have that protection for nonprofit organizations as well, since they are a corporation in the state of Florida. However, that business entity protection can be pierced, as we call it, if the business is not operating in accordance with all of the applicable laws and internal regulations of the corporation. And in that case, for example, one example that I always give is you have a nonprofit organization and there's a board of directors, and they have hired a chief executive officer that they pay to run the day-to-day operations of the business. And instead of the profits that the nonprofit organization makes or the revenues that the nonprofit organization generates being deposited in a separate bank account for the nonprofit organization, the revenues or some of the revenues are deposited in some of the directors' bank accounts or the CEO's personal bank account. Now, if something happens to that nonprofit organization and someone sues the organization, the lawyer that files the lawsuit is going to look and see that all of the corporate financial accounts are kept separate and that the corporation has its own banking and is responsible for its own money and is separate from all the officers, directors, and employees. If they find that it's not separate, they can say that actually the corporation is not operating as a business entity, but is the alter ego of whatever individual they're trying to go after assets for.
Okay, thank you. Looks like someone's asking, can we sell t-shirts and merchandise on our website?
If it's related, the short answer is if it's related to your nonprofit purpose, then the general answer is yes. The profits that you make from the t-shirts would need to be reinvested back into your nonprofit in accordance with whatever your mission is, whatever your charitable educational or other 501c3 purpose is.
Okay. Can you explain the issue of nonprofits owning property under the primary entity?
So this surrounds around liability issues primarily. So many nonprofit organizations are lucky enough to own and hold valuable pieces of real estate. And if the nonprofit organization holds title to the real estate in its own name, in the parent corporation's name, let's say, God forbid, something happens on that property, someone is injured. The aggrieved party, the injured party, is going to file a lawsuit against the owner of the property. And if it's the parent corporation that's the owner of the property, that exposes the parent corporation up to 100% liability with regard to the property. So if the parent corporation has a substantial amount of assets or has grant funding, those funds could be placed in jeopardy. We recommend that instead, if a nonprofit organization is going to own a piece of property, that piece of property be held in a separate entity. Normally, for example, we would create a limited liability company where the sole member is the nonprofit organization, and then the property would be held in that special purpose entity, where the only purpose of that entity is to hold title to the property, and that entity has no other assets except for the property in question. That way, if somebody is injured on that piece of property, they sue the entity that actually holds title to the property, which is the LLC, and their liability limits are up to whatever that piece of property is. Now, hopefully, you also have insurance, and that's your first line of defense, right? So they would sue under whatever insurance policy you have, under whatever property insurance liability policy you have for that property, and the limits of the liability would be up to your policy limits. But let's say the liability exceeded your policy limits. Then they would only be able to go after the LLC, and the only asset that the LLC owns is that property. They wouldn't be able to go after all of the other assets of the parent corporation that the nonprofit 501c3 actually owned and held.
Okay. The next one is, what are the rules for social media? I'm assuming are there any legal issues regarding social media?
So the one, that's a very broad question, so I'm not exactly sure what they're trying to get at. But the one thing that I can think of that has come up in the past couple of years are the limits on lobbying. There are instances where nonprofit organizations have blog pages or Facebook pages or Twitter accounts. And someone from the organization, whether it be an employee on behalf of the organization or an individual board of director or someone else associated with the organization, will go on those Twitter feeds or the Facebook account and post something about a political candidate, or they will post an article in favor or against a piece of legislation. And that is considered lobbying. So nonprofit organizations need to be very careful about those social media accounts when it comes to lobbying restrictions.
Okay. Can a nonprofit pay its president, and what is considered excessive compensation?
So the general answer is that it depends on a variety of things. But if you're saying, can a nonprofit pay a president, and by president you mean somebody that's responsible for the day-to-day affairs of running the organization, like a chief executive officer, then yes, the nonprofit can pay that individual. A paid employee of the nonprofit organization is permitted to also sit on the nonprofit's board of directors. However, if that is the case, there needs to be a robust conflict of interest policy that is adopted by the organization and also adhered to. For example, problems come up where you're sitting at the board of directors meeting and the president, who is paid a salary by the board, who is also sitting on the board, votes on his own or her own compensation structure. That is completely disallowed. So you have to be very careful if you're going to engage in that kind of dual role. You have to understand the dual role, and you have to make sure that all of the other board members have approved and authorized it. And the president, who is also on the board of directors, that is also running the day-to-day affairs of the company, that is getting paid, there needs to be sufficient conflict of interest policies in place and protections so that there's no appearance of impropriety or self-dealing or private enormity.
Okay, and it doesn't look like we have any other questions. I, though, wanted to know, what services do you provide, not you personally necessarily, but Legal Services of Greater Miami, Inc., the services that you provide for nonprofits?
Sure. So here at Legal Services, we have a community development and affordable housing division, and we represent qualified nonprofit organizations on a variety of legal issues, not just affordable housing matters. So if you are a nonprofit organization and you are having issues with real estate or contracts or employees, if you have questions about leases or drafting agreements with joint venture partners, land transactions, anything that your nonprofit organization has questions about that are legal in nature, we likely could provide assistance to your organization. We require that in order to provide that type of legal assistance that you are screened as a client, and there are various things that we ask for, such as your organizational documents, a letter on your organization's letterhead stating that you are unable to afford to pay for a market rate attorney and why you need our services, and a copy of your most recent Form 990. We also represent qualified small businesses that are not nonprofit organizations but are for-profit organizations, as long as those small businesses are either comprised of low-income individuals or serve a low-income population. So if you're interested in those services, you can contact me. Susan will provide my name and my phone number at the end of the presentation. And we also have a new partnership that Legal Services is involved with. It is a collaboration among 3 legal services programs in the Florida region, and we have collaborated and formed a partnership called Florida Community Development Legal. The website should be up and running by February 1st, and it's really an expansion of the services that Legal Services of Greater Miami provides under its Community Development Division. It's just that now we can serve a wider service area. So our service area is anywhere from the Orlando area down through Key West currently, and we have 7 attorneys on staff, and we are able to deal with a multitude of legal issues that relate to nonprofit organizations, particularly in the affordable housing arena, and also to small businesses that qualify for our services.
Great. It looks like we have another question. Can board members be paid a stipend?
So it's not that board members cannot be paid a stipend. However, it is strongly advised against. And this is one of the things that the IRS sees as a red flag. So the question is, why are you paying board members and what are you paying them to do? And then who then is voting on paying those board members? That's really the main issue. So your board is the one that's responsible for voting on policies and setting agendas and ratifying decisions of your nonprofit organization. So how then is the board able to ratify and vote on their own compensation. It becomes a very, very sticky issue. And so generally we say that board of directors should not be compensated. Officers, if they are employees and doing services for the organization and working for the organization and they have dedicated tasks, they can be compensated reasonably. But in general, it's not a good idea to compensate your board of directors.
Okay, great. Thank you so much, Shar. I really appreciate you giving us all this knowledge today. If anyone has more questions for Shar, you can feel free to contact her at the email address on your screen. So just to let you know, the follow-up email that you'll receive after the presentation, probably tomorrow, will include a webinar recording and an evaluation, and we'd really appreciate it if you could fill that out for our knowledge. I also want to give a big thank you to TD Charitable Foundation. They're one of our funders, and we really appreciate them. And we really appreciate you for joining us today. If you're interested in more webinars that we'll be hosting and other in-person events, feel free to go to our website at southfloridacdc.org. Thank you so much.
Thank you, everyone.